A House Judiciary Committee hearing took an unexpected turn when Congressman Chip Roy pressed Attorney General Pam Bondi on one of the most closely watched questions surrounding the Epstein investigation. The discussion focused on victim protections, document releases, and whether additional individuals could still face prosecution based on evidence currently under review. Watch the exchange first, then we'll break down what was said, what remains unknown, and why this testimony immediately drew attention.
Am I correct that under your leadership, the Department of Justice has prosecuted cases of non-citizen voting? So it's false, as some of my Democratic colleagues have claimed, that it doesn't happen.
Yes.
I ask that today because we're voting on the Save America Act today to enact common sense policies to ensure only American citizens vote in American elections and enact federal voter ID laws. But it's true, for example, that in just this month, a federal grand jury in Newark indicted two men with illegally voting in federal election and making false statements. Mohammed Mazammel and Mohammed Shakil were non-citizens at the time they registered to vote. This happens, it happens regularly, and you're prosecuting those crimes, correct?
Yes.
But does that prosecution of those criminals overturn their previously cast votes?
That's all pending.
But it does not overturn votes that they've cast, right? So passing the Save
no,
America Act would help deal with that problem.
Yes, Congressman.
Second question. As Attorney General, you're in charge of the Executive Office of Immigration Review, correct?
Yes, Congressman.
The Biden-Mayorkas regime caused the immigration court case backlog to explode, correct?
Explode.
Does that sound about right, that in September of 2020, 4 months before President Biden took office, there was a backlog of 1.5 million cases, but by the time President Biden left office, the backlog reached nearly 4.2 million cases?
It sounds about right, but I don't have the exact numbers.
It would be accurate to say that most individuals who file for asylum have a meritless or fraudulent claim?
Most. I don't have the numbers.
Oh, so does it sound correct that of the asylum cases adjudicated in FY 2023 under the Biden regime, that only 14% resulted in an asylum grant and only 12% in fiscal year 2024? Does that sound correct?
It sounds correct. I'm sorry, I don't have the numbers.
Could you get that information to us to verify that data?
I'll get all that information to you.
Under the Trump administration, immigration judges complete an average of 65,000 cases per month, the highest average completion rate in at least a decade. Does that sound correct?
That sounds correct.
Ms. Bondi, how many new cases under EOIR received in fiscal year 2025 have you all had? And of those, what percentage have been granted asylum? Do you know?
I can try to get you those numbers. I thought I had those.
That'd be great, because my question is whether President Trump's decision to pause asylum in the wake of the shooting of a National Guardsman by an Afghani here in Washington, D.C., in the nation's capital, helped to stop the backlog in your office. Does that sound correct?
Yes, Congressman.
My point being that the leadership of this administration is ending the backlog, reducing the backlog, making sure that we don't have fraudulent asylum claims clogging it, and keeping Americans safe. Is that correct?
Yes, Congressman.
So a couple other quick questions on another important topic that has been raised by colleagues on both sides of the aisle with respect to the Epstein case. A few questions. One, Jeffrey Epstein was charged in July 2019 for sex trafficking under the Trump administration in his first term. Is that correct?
Yes, Congressman.
And that Ghislaine Maxwell was charged in 2020 also under the Trump administration, correct?
Yes, Congressman.
So it is safe to say that the administration led on that issue and that there was silence in the previous administration. Is that correct?
Yes, Congressman. Almost complete silence from everyone who's been trying to still talk about Epstein. They didn't say a word under the Biden administration. Nothing.
And I want to make one other point and then another question, though, that is important. I want to make one observation, and that is that we've heard the information today, which is troubling, that Jane Doe's, that victims' information was made public and was unredacted in the files that were released on Friday. So my question is, some of us had argued when we were dealing with the discharge petition in Congress, that when Congress inserted itself into the process, that we needed to be very careful to ensure that we were protecting victims. So a question that is both, I just want to make that clear that some of us were fighting for that here and we didn't get a chance to amend it or change it. So that was concerning. But a question a little more pointed, I have to say, is why, though, were the victims' names released that shouldn't have been? That there were names in the files, that these Jane Does, that their names shouldn't have been made public when there were some accusers whose names were redacted? That's question one. Mm-hmm. And question two was that Ghislaine Maxwell was put in jail for trafficking minors. Rightly so, and you properly said here at this table, you hope she dies in jail. Well, I want to know, will anyone besides her or Epstein, which I congratulate President Trump's previous administration and this Department of Justice for continuing all of that, but that they were indicted, but will anyone else be indicted and prosecuted under this, given the information that's in front of us? So two questions.
Thank you for letting me answer that. They didn't want to hear my answer on the other side. Yes, given the tight time frame of 30 days, I believe we got everything released within a little over 60 days. I'm talking as fast as I can. My time is up. We did the best we could immediately. If everyone's been coming to view the documents, if someone's name should not have been redacted, we're releasing it. If someone's name was redacted, we said right away, was not redacted and should have been, meaning a victim. We went back and redacted it. We're doing everything we can based on the tight time frame and over 3 million pages that we released that Donald Trump signed for pure transparency. Second, what was your second question?
About whether another individual will be indicted.
Oh, absolutely. Thank you for asking that. And they never wanted to hear the answer to that. We have pending investigations in our office.
What made this exchange significant was not simply the mention of the Epstein files. The hearing touched on a much larger issue that has remained in the public eye for years: whether the American public has been given a complete picture of the Epstein investigation and whether accountability has reached everyone who may have been involved in criminal conduct. Congressman Chip Roy used his questioning time to focus on several subjects, but the discussion became most notable when he turned to the Epstein case. Before getting there, however, it is important to understand how he structured his questions because the order itself reveals the broader argument he was trying to make. Roy began by discussing election integrity and immigration issues. He highlighted prosecutions involving non-citizen voting and then shifted toward immigration court backlogs and asylum claims. The purpose of this line of questioning appeared to be establishing a broader narrative about enforcement, accountability, and the role of government institutions. By the time he transitioned to the Epstein investigation, he had already framed the conversation around the idea that government agencies should enforce laws consistently and should be judged by their results. That context matters because when Roy eventually moved to the Epstein case, he did not begin by asking about conspiracy theories, leaked documents, or internet speculation. Instead, he focused on actions that had already been taken by the Department of Justice. Specifically, he pointed out that Jeffrey Epstein was charged in 2019 and that Ghislaine Maxwell was charged in 2020. His argument appeared to be that the legal process had already produced significant results and that those actions occurred during the first Trump administration. Whether viewers agree with that framing or not, it was clearly central to his line of questioning. Roy was attempting to contrast criminal prosecutions with the political debates that often dominate discussions about the Epstein files. Rather than focusing on rumors, he focused on what had actually happened inside the justice system. The hearing then shifted toward one of the most sensitive aspects of the entire controversy: the release of records and the protection of victims. One issue that has received increasing attention is how government agencies handle large document releases related to high-profile criminal investigations. In cases involving sexual abuse and trafficking, transparency is important because the public wants to understand what happened and whether justice was served. At the same time, victim privacy is critically important because releasing identifying information can cause further harm to people who have already suffered significant trauma. Roy referenced reports that some victim information may have appeared in released materials without proper redactions. This is a particularly serious concern because once information becomes public, it can spread rapidly online and become impossible to fully remove. Attorney General Pam Bondi responded by explaining that corrections had been made when problems were identified. She emphasized the challenges involved in processing and releasing millions of pages of material while attempting to meet transparency goals. This portion of the hearing highlights one of the most difficult balancing acts in modern government. On one side, there are demands for maximum transparency. On the other side, there are obligations to protect victims. Most people support both objectives. The difficulty arises when those objectives come into conflict. Advocates for transparency argue that the public deserves access to information about investigations involving powerful individuals. They believe that secrecy can undermine public trust and fuel speculation. Advocates for victim protection argue that no disclosure goal should come at the expense of exposing victims to additional harm. The hearing demonstrated that policymakers continue to struggle with finding the right balance between these competing priorities. The conversation then moved to the issue that generated the most attention: future prosecutions. For years, one of the most common questions surrounding the Epstein case has been whether anyone besides Epstein and Maxwell could eventually face criminal charges. This question persists because many people believe the case involved a broader network of individuals. Some of those beliefs are based on court records, witness testimony, media reports, and public allegations. Others are based on speculation and assumptions. Distinguishing between those categories is important because the legal system operates on evidence rather than public suspicion. When Roy asked whether additional individuals could be prosecuted, Bondi's answer immediately attracted attention. She stated that there were pending investigations. The significance of that statement depends largely on how it is interpreted. Some viewers immediately viewed it as evidence that new charges are coming. Others viewed it as a routine acknowledgement that investigative work continues. From a legal perspective, it is important not to overstate what was actually said. Bondi did not announce an indictment. She did not identify suspects. She did not suggest that charges were imminent. She did not provide timelines. She did not indicate how many investigations are active. What she did say was that investigations remain pending. That distinction matters because active investigations can lead to many different outcomes. Some investigations result in prosecutions. Some result in additional evidence gathering. Some are referred to other agencies. Some are closed without charges. Because of that reality, viewers should be cautious about drawing conclusions beyond what was actually stated during the hearing. At the same time, it is understandable why the statement attracted attention. For many Americans, the Epstein case remains unresolved. Not unresolved in the sense of whether crimes occurred. The criminal conduct of Epstein has already been established through legal proceedings. Rather, unresolved in the sense that many people continue to wonder whether every individual who committed crimes has been identified and held accountable. That question has persisted across multiple administrations and has become one of the reasons the case continues generating public interest years later. The hearing also revealed a deeper issue involving public trust. One reason the Epstein story refuses to disappear from public discussion is that many citizens have lost confidence in institutions. When information is withheld, even for legitimate legal reasons, some members of the public assume there must be something more being concealed. Government officials often respond that investigations require confidentiality, that victim information must be protected, and that legal standards limit what can be disclosed. Both perspectives can exist at the same time. The public wants transparency. Law enforcement requires certain restrictions. The tension between those two realities was visible throughout this exchange. Another important aspect of the hearing was the contrast between political expectations and legal realities. Political discussions often move quickly. News cycles demand answers immediately. Social media rewards certainty and speculation. The justice system works differently. Investigations can take months or years. Evidence must be collected and verified. Witnesses must be interviewed. Legal standards must be met. Prosecutors cannot simply bring charges because there is public pressure to do so. They must be able to prove allegations in court. This difference between public expectations and legal procedure often creates frustration. People see unanswered questions and assume nothing is happening. Investigators may see unanswered questions and view them as reasons to continue gathering evidence. The hearing reflected that gap between what the public wants to know and what officials are willing or able to disclose. The broader political context also played a role. Over the years, the Epstein case has become a subject that crosses ideological lines. Conservatives, liberals, independents, journalists, activists, and victims' advocates have all raised concerns about different aspects of the investigation. Some focus on transparency. Some focus on accountability. Some focus on victim protection. Some focus on government credibility. What makes the issue unusual is that criticism has come from nearly every direction. That reality helps explain why hearings involving the Epstein files continue attracting significant attention. People who disagree on almost everything else often agree that they still want answers. By the end of the exchange, the central question remained unresolved. Will there be additional prosecutions? The hearing did not provide a definitive answer. What it did provide was confirmation that investigative work remains ongoing. For supporters of greater transparency, that may not be enough. For defenders of the legal process, it may simply reflect the reality that investigations cannot be conducted in public. Regardless of where viewers stand, the exchange highlighted why the Epstein case remains one of the most closely watched criminal matters in recent American history. It combines issues of power, accountability, transparency, victim protection, public trust, and institutional credibility. Those themes extend far beyond a single defendant or a single court case. They speak to broader questions about whether the justice system treats powerful individuals the same way it treats everyone else, and whether the public can have confidence that investigations are being conducted fairly and thoroughly. That is ultimately why this hearing mattered. It was not merely another discussion about documents or redactions. It was a public reminder that many Americans still believe important questions remain unanswered and that lawmakers continue pressing federal officials for clarity. Whether future investigations result in additional charges or not, the exchange demonstrated that the demand for accountability and transparency remains as strong as ever. And until the public feels those questions have been fully addressed, hearings like this will continue to draw attention, generate debate, and keep the Epstein investigation at the center of public discussion.